Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled Attorney Files RICO Civil Rights Suit Against St. Louis Family Courts Part 2. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Okay, so this video again will be part 2. So for those who haven't watched part 1, simply pause this video, go back and watch part 1. Once that's over with, come back and pick it up at part 2 so you all can be brought up to speed on what's going on. So for those who did watch part 1, as I stated at the end of the video, that I will go over the actual complaint once I received it. And as you all can see on the screen, I have the actual complaint. But before I go over the complaint, I'd like to, just give a heartfelt shout out to the attorney who is trying his best, but he's just simply going about it the wrong way. But as an attorney, I'm surprised that he would go this method, and he should know that he shouldn't take this route, especially in federal district court. But I don't know if he got caught up in these Facebook groups and just listening to individual on the internet telling you all to go to federal court. But that stuff do not work, guys. Why? Because federal district court is the wrong court to file your federal lawsuits in, especially if you are a state court loser. So now, let's pick this up at the top. As you all can see, this document was filed on August the 8th. August the 11th, 2025. And it's 170 pages, guys. So I don't have time to go over 170 pages, but I can pick up on where the case is going to go by reading the probably the first paragraph at most. But I'm going to go a little bit longer than that, probably a page or two, just to break it down, and then I'll go over case law and stuff like that to support my stance on why I believe why the case will be dismissed, on the grounds that it will be dismissed on. So let's pick this up at the very top where it states United States District Court, Eastern District of Missouri, Eastern Division. So left hand corner it states what? It states Matthew R. Grant. Matthew R. Grant is the individual, aka the attorney that's bringing the suit. Okay? But he's bringing the suit as what? As next to friend. Next to friend to who? Next to friend to his two minor sons. Okay? But let's read it. It states Matthew R. Grant individually as next to friend to CLG and as next to friend to CMJ and on behalf of all others similar situated. Then it states and Stop Missouri Corruption LLC. So Stop Missouri Corruption LLC is in fact Matthews R. Grant LLC. So I guess he's fighting the corruption in the state. So he wanted to bring his corruption fights to federal district court, which is the wrong place to bring them. But let's continue on. So as plaintiff, he is the attorney, and his LLC is Stop Missouri Corporation, and they're moving the court as next to friend on behalf of his two minor children. Okay? On the face value, it looks like, that's a good idea, or that this idea will work. And he also believed that this is a good idea, but he didn't do enough research to see that this is an absolute nightmare, and he should never filed it this way. But let's continue. That's just my opinion, guys. But like I stated, I'm here to tell you all the truth and nothing but the truth. Okay? First, the truth will make you mad, and then you will accept it. Okay? And once you accept the truth, you will become free. But first, you gotta want to accept the truth. Because the truth shall what? The truth shall set you free. So, if you run across individuals telling you all to file federal lawsuits in court, your first response to them is show proof that you won a federal lawsuit in court, starting with your own. If they cannot show you that they won a federal lawsuit pertaining to child support in federal district court, then stay away from them, guys. 9 times out of 10, the moment you ask, the first thing you're going to hear is crickets and then a bunch of excuses, and then they're going to get upset with you and then try to make you feel bad for you asking them to show proof of the results that they claim that they can get you. And it's just that simple, guys. But let's continue on. So he's up against all of these plaintiffs, guys. So I'm going to, Scroll down so you all can read them. Okay, read every one that's attached. And he also added co-conspirators as well, 1 through 100. Okay, so again, this is page 2, but let's continue. It states individual class action, civil racketeer influence and corrupt organization, RICO Act, 18 U.S.C. subsection 1964, Civil Rights Act, 18 U.S.C. subsection 1983, and other causes of action, complaint. But let's continue. So this is in fact a complaint. And it reads, Plaintiff Matthew R. Grant, right? Let's see what stands out to you guys. I'm going to teach you all how to read a legal document. It states plaintiff or plaintiff MRG or father. So what stands out right there, guys? He is the father, okay? He's taking on the father status. But let's continue. It states individually and on behalf of and as next to friend, okay? For who? For his minor child. Let me see, minor child, okay? CLJ, and on behalf of and as next to friend for his minor child, CMG. Okay, so he's again next to friend for CLG and CMG, but those are his children because he's claiming to be the father, right? Right. Okay, so what I tell you guys about the Rooker-Feldman doctrine. Once you become a state court loser, you cannot petition or use the federal district court as a court of appeals to try to overturn the decisions that's made in the state court. Okay? That's one grounds, but let's continue because we're going to break this thing all the way down. Then it states plaintiff CMJ, plaintiff CMG, collectively the children, and on behalf of all others similarly situated, the comprehensive class or class and subclasses, and plaintiff Stop Missouri Corruption LLC, plaintiffs LLC. So again, Stop Missouri Corruption LLC is in fact the plaintiff LLC, who is what? Who is Matthew R. Grant, who is what? The father standing as what? Standing as next to friend for his 2 minor children. I hope you guys are following me, okay? Let's continue. Then it states collectively plaintiffs for their individual class action, civil racketeer, influence, and corruption organization, RICO Act, 18 U.S.C. subsection 1964, Civil Rights Act, 18 U.S.C. subsection 1983, and other causes of action, complaint against the named defendants and those to be added in the future states as follows. Then let's pick this up at preliminary statement. So the first paragraph was okay. He broke down his stance of who he was, who he's next to friend for, and how his LLC is also involved to help him litigate this matter. But let's continue. Then it states plaintiff statement, and it reads, like I tell you guys, after I read this first paragraph, I can break this whole thing down and let you all know how he's going to lose. But let's continue. It states preliminary statement. Plaintiff Matthew R. Grant is the father of 2 teenage boys, aged 14 and 16, and what? And he lost all custody and visitation rights last March. So again, guys, it states clear as day. He lost. Hold on, let me see if I can highlight it. Oops, keep moving. He lost all visitation rights pertaining to his children. Okay, as highlighted last March. So he lost all visitation and all custody. That's the whole reason for this lawsuit. So once the higher courts or the federal district court judges read this, the first thing they're going to say is this is no more than a state court loser trying to petition the federal district court to overturn a state court ruling and trying to use the federal district court as a court of appeals. They're going to automatically bar this suit underneath the Rooker-Feldman doctrine. But let's continue. It says, when he exposed the corruption that exists in the St. Louis Family Court and the 21st Circuit Court of the state of Missouri for St. Louis County, Missouri, St. Louis Family Court to the Missouri Court of Appeals for the Eastern District of Missouri, Courts of Appeals, and then the Missouri Supreme Court, just recently, plaintiff has regained 1 night per week to spend with these young men. This 1 night that will soon be removed is the only time that these young men have with their fathers during critical years in their lives when sons need their fathers the most. So again, guys, as you all can see on page 2, he's simply breaking down his relationship to the children. So he's a father that lost the majority of his time with his children, and because he lost the majority of time with his children, he's claiming that there's some form of corruption going on. And he may be right because the district court is going to pursue his, or they're going to read his complaint as everything stated in there as factual. But just because you filed a factual complaint, you have filed it in the wrong court and you're challenging it in the wrong place. But let's continue. So now we're on page 3. It states, critically, before the underlying case was filed, plaintiff has had at least 50-50 joint legal and physical custody 15 nights a month since the day the children were born. Same thing we read in the article on what? On the part 1 of the video. But let's continue. Then it states, as may be most relevant to the motive of the defendants in this case, plaintiff is also a Missouri licensed attorney with background that brings credibility to his claim unlike any case ever brought before. So again, guys, the attorney is mistakenly confusing himself. He he believes that he has more credibility than anyone else who brings their same claims into the federal district court, which is a simple lie, guys. He's confusing his own self, and he's basically fooling himself. Because when a plaintiff files a complaint inside the federal district court, the federal district court always perceive the plaintiff complaint most factual or most unfavorable to the plaintiff. Okay, so they always assume the plaintiff complaint to be factual or true outside of anything. But even if the court construes your complaint as factual or true, or holds your complaint as factual or true, that still doesn't mean that they can make a ruling in your favor, especially when the court lacks jurisdiction to do so. So they will do what, guys? They will simply dismiss the case for Rule 12b1 and 12b6 for failure to state a claim upon which relief can be granted. And not only that, because he was a state court loser and he's trying to now petition the federal district court, they will also dismiss his claim for what? Rooker-Feldman doctrine. But not only that, guys, they will dismiss his claim because the state and his actors have sovereign immunity. They're going to also use that and many more that I haven't went over yet, guys. But we're going to break this all down. So now let's pick this up in the middle again, where it states plaintiff, right there highlighted in blue. It states plaintiff is not just an attorney, but a litigator, a courtroom lawyer who practiced for 21 years at a huge law firm that is one of the 100 largest in the United States. His skills led to him being named a partner in that well-known law firm, and there plaintiff learned the Republican political network and inner workings that are behind the very conduct at issue in this case. It is plaintiff's credibility and his evidence that has led to this case receiving attention from the Missouri Supreme Court unlike any other. Of course, you're going to get a lot of publicity because you are an attorney, but you should have got remedy in the Missouri Supreme Court, or even in the Missouri Court of Appeals if you filed your appeals and stuff right. Especially if you're claiming to work at one of the highest law firms in the United States, one of the top 100 law firms in the United States. So it's a pretty big law firm. But he's making rookie mistakes and he should have did more research before actually filing this complaint, especially this RICO. Right? We're going to even break down the RICO and that the RICO has no standing in this case. But let's continue. It states right here, guys. Now, right, highlighted in blue, now, because plaintiff would not recant and disavow his truthful claim of criminal corruption involving the parties in this case during his June 23rd, 2025 trial, the guardian litem defendant, John Finley, has recommended taking that one night each week away and cutting it by half. This is retaliation for plaintiff exposure of the corrupt scheme to everyone plaintiff can think of that can help, including the United States Department of Justice, the DOJ. As discussed below, the very assistant United States attorney that used to work with plaintiff at a huge local law firm has refused to even respond to plaintiff's complaint. This lawsuit will present evidence from many others that have personally met with agents with the Federal Bureau of Investigations, the FBI, year after year, only to encounter the same refusal to intervene and stop this criminal activity. So again, guys, he's right about that. There is a criminal enterprise going on, but you're in the wrong place trying to fight the criminal enterprise. And it's just that simple. You can make all the claims and the allegations that you want, and they're going to construe your claims and allegations as facts. But you're in the wrong spot, buddy. But let's continue. Then it states, recently, plaintiff recorded a phone call from the defendant and guardian ad litem, John Finley, that took place on June 2nd, 2025. In that recording that will be introduced into evidence, in this case, Finley attempted to extort plaintiff via coercion and trade him custody of his children if he agreed to disavow and recant his claims of criminal corruption. So again, guys, he's basically saying that he has a recording. That recording will never see the light of day in that court. Why? Because all the plaintiffs is going to file a motion to dismiss, and the court is going to grant the motion to dismiss. Probably not for the those that are acting in their private capacity and stuff like that, but all the big wigs, they're going to be covered under the 11th Amendment of immunity. And by the time they remove themselves, it's going to also remove some majority of the corruption that was done by anybody else who is not considered to be one of the arms of the state, or an official acting on behalf of the state who's immune underneath the 11th Amendment. And it's just that simple, guys. But let's continue. It states, uh, right here, highlighted in blue so you all can see, it states plaintiff refused and instead submitted that record to the Missouri Supreme Court. And again, the DOJ is in ongoing efforts to end the criminal organization that rules the family court. In retaliation for plaintiff, a victim continued to pursue criminal prosecution of all involved, disbarment of lawyers and judges, and removal of the judge and commissioner from the bench in St. Louis County. The RICO defendants in this case retaliated in violation of federal law. Now, instead of the 4 overnights per month plaintiff has, hold on, let's stop right there. So, if they did all that, right, why are you still keeping it on the 4 nights for your child? His argument was to keep it straight on what's going on in the corruption. But instead, he's not really worried about the corruption. He's just worried about him losing custody time, which is why he will lose this case. And it's just that simple. But let's continue. Pick it back up at the first line. It states, now, instead of 4 overnights per month, plaintiff has now, defendant Finley is recommending only 2 overnights per month from now until each child turns 18 years of age. It is shameful, it is a criminal, and it is a violation of plaintiff and his children's due process rights. So now, guys, as you see, he's still going back to the custody. He lost custody, and if he didn't lose custody, guys, again, there would be no case. So I'm going to stop right there because I don't want to go too long. So what I'm going to do now is go over and show you guys what I believe is going to transpire by using case law. So now, since it's a RICO, let's address the RICO. Let's see if these actors that he's calling and the defendants that he's going against, let's see if the RICO applies to them. Let's go there. Okay, so we went over 3 pages in the complaint. But as I told you guys, I could have stopped it right after the first paragraph. I already knew what was going to happen or transpire. But, just to get a guy a fair shake and to let you guys get sort of a gist of some of the complaint, like I said, I'm not going over that whole 100 pages for something I know is going to happen. So now let's break it down. We know that he's have a RICO against the state and its actors and the arms of the state. So, and those who are not actors of the state, such as the child's mom and their family members, that will also get thrown out once the state portion get thrown out. Because without the state involved, then that makes the RICO Act or the RICO case extremely weak. But let's continue reading though. So let's pick this up at number 1 to see if RICO applies to the state. And it reads, 1. States and their agencies are not what? Are not persons under RICO. Let's pick this up at the case law. Will versus Michigan. And it reads, the Supreme Court has held that a state is not a person within the meaning of subsection 1983. So because the state is not a person underneath subsection 1983, which is the civil rights claim, then that automatically throws out his subsection 1983 claim. Why? Because the state is not considered a person underneath 1983 to be sued. But let's continue reading. It states what? Courts have applied this reasoning to what? To RICO, concluding that Congress did not intend to subject states to private suits under person liability provisions absent a clear statement. So again, guys, what do that mean? What clear statement are they referring to? They're referring to Congress coming out stating that the state waives its sovereign immunity to be sued underneath RICO underneath 1983. So if you have a RICO claim against the state or a 1983 claim against the state, Congress has now waived this immunity to allow those to sue. Congress did not do that. You cannot find that statement, and without that statement, your lawsuit is already over with and done. Okay, and it's just that simple, guys. So that's why I'm telling you all to stay out of federal district court. Despite what all these other channels are trying to tell you all and the lies that they're spreading and fabricating, I'm going to show you all the truth and I'm going to put it out there for all to see. Okay? I still haven't seen no lawsuits yet and winning in federal district court. Why is that? Because I'm showing you guys why. It cannot be done. But let's continue. It states Berger versus Pierce. Then it reads the Sixth Circuit held that a federal agency is not a person under RICO. This rationale has been extended to what? To states and their subdivisions. So not only federal agents are not present in RICO, so are states and their subdivisions, meaning states and their arms of the state. Okay? So if you cannot sue the state and its arms of the state, anything else outside of that, you're just throwing air at the wind. You're going to lose. You're not going to hit anything. You don't. Your case crumbles at the beginning. So he basically lost the case before it started. That's why if you go back and you click on the initial filing, it's all the parties accepting service. They all accept the service voluntarily. They voluntarily accept the service. Why is that? Because they know even after being served, that still doesn't give the court jurisdiction over them. Why? Because they still stand underneath their sovereign immunity. So it's going to get thrown out. But let's continue. Let's go to McNeil versus United States. And it reads, the Fifth Circuit found that federal agencies cannot be liable under RICO, reinforcing that government entities are not RICO persons, as you all can see. So just because it's a government entity, there are not RICO persons, they cannot be sued underneath the RICO Act. Like the Bible tells us, guys, a divided house cannot stand. Devils cannot cast out devils. Satan cannot cast out Satan. So a house divided will not stand. So there's no way criminals are going to make a or sign some type of act that's going to get them punishable. It's not going to happen like that, guys. But let's continue on. So again, guys, his RICO suit is done and over with. That part is thrown out. But he's also claiming what? That he filed it in the district court. So let's see what the district court has to say about this. Let's go there. Let's get more understanding, guys. Let's break this thing down to nothing. Let's go there. Okay, guys, let's pick this up at the top where it states district court specifically applying this to states. Picked it up at the very top, guys. Highlighted in the red. Never case law to support it. Government entities are incapable of forming the malicious intent necessary to support a RICO action. They cannot be held liable under what? Under RICO. So again, guys, this is going for the states as well. This is in the district court. But let's continue on. Another case law. City and County of Honolulu, not a RICO person. More case law to support that. Let's continue on. States as a state agency are not RICO persons, guys. So again, case law after case law after case law to support the truth. The truth is going to be the truth, guys. Remove emotion. Get the truth. The truth just sets you free. Don't worry about the emotions. Yeah, you're going to be upset knowing that the criminal enterprise is running rapid. But if you do things the right way, you can win. Believe me, I know. I've done it multiple times for myself and for others. But now, since they stated that, let's go to the next of kin or the next of friend, since he's filing his court case as next of friend. So we prove that the RICO Act does not apply to states or their officials. Now let's go to his crafting ways of him trying to move the court as next of friend on behalf of his children using his LLC and him being a lawyer. Let's see what that hold up in the federal district court. Let's go there. Okay, so as I showed y'all at the beginning of the video, that the father was bringing the complaint as next friend. So let's see if that gives him standing in court to receive remedy. Let's pick it up at the first case law, TW versus Brophy, and it reads, parent lacks standing as what? As next friend. That automatically wipes it out, guys. But let's continue reading to assert child's claims where the litigant was in substance and collateral attack on custody proceedings. Remember, guys, I told you this whole case is revolving around the custody proceeding. If it wasn't for the custody proceeding, then he would not have a claim. Okay, he's claiming that all this wickedness is going on and all this corruption is going on. Why not just sue them straight out, minus the custody claim? Just go straight after them and the corruption. He could probably win that. But because he's trying to use the custody to bring the RICO, he's automatically lost his case. But let's continue. Next case law to support that, which is Elk Grove, and it reads, non-custodial parent could not bring a constitutional challenge as next friend of his child because his standing was entangled with domestic relation issues reserved to state courts. So again, guys, domestic relations also deals with what? The parent-child relationship, child support, custody, and everything else. It's all domestic relations. But let's continue. Let's go to finish the maker. And it reads, next friend, standing cannot be used where the real party is able to litigate or where the suit is effectively asserting the filer's own interest. And that's the truth. This case is pertaining to the filer's own interest. It had nothing to do with the children, even though he's trying to move it on behalf of the children, but it's simply based off the custody order that he received by him being an attorney. He cannot accept that that L. So because he's losing left and right, he wants to now try to file a conspiracy RICO, but he's filing it the wrong way. If he really wanted to hurt the state and its subdivisions and stuff like that, he will file the claim absent the custody order. But again, he don't have a claim after the custody order. That's why he's trying to use the custody order in order to petition the district court. Let's go to the next case law, and it reads, the doctrine is limited and applies only when the real party is unable to litigate for themselves. So again, that's just more proof, guys. So again, we've proven that next to friend don't apply. But let's continue on to the next case law. Let's go there. Also, as I stated all throughout the video, that the 11th Amendment bars the claim, here's more case law to support that. Now let's read number 2. 11th Amendment sovereign immunity bars RICO claims against states, and it reads in Quan versus Jordan, Congress must make an unmistakably clear statement to abrogate 11th Amendment immunity. RICO does not. Okay, so the RICO does not bar the 11th Amendment immunity. But let's continue on. More case law. It states what? Held that Congress did not abrogate states' 11th Amendment immunity in enacting RICO. So again, the 11th Amendment immunity still applies underneath the RICO Act. But let's continue. It states, next one in Livingston, it reads, reinforces that absent clear intent, state retains immunity from federal private suits. Again, guys, same thing. Let's go again. Burge, and it reads, explicitly holds that RICO does not abrogate 11th Amendment immunity and states cannot be sued under RICO. So again, guys, the RICO is gone. The 11th Amendment applies. The Rooker-Feldman applies. And also next to friend fails. So because these 4 strong points bars the whole case from the start. So again, he's wasting his time, energy, and money. He could have just came to me and I could have told him that it wasn't going to work. But hey, easier said than done, guys. Once your emotions get involved, you don't want to hear anything if it don't sound good to you. But it's not what it sounds like. The truth is going to be the truth, guys, and the truth will set you free. So that's what I'm going to do for today. As you all can see, again, guys, I'm just dropping this truth and bringing this knowledge to you all. I haven't been making a lot of teaching videos because it's all these new child support teachers out here, man. You know, and I let them have it, guys. They can teach all day long. I just want to show proof. And I'm going to just keep providing this proof and applying this pressure. While they all teaching, I'm showing proof. Okay, so that's all I'm going to do for today. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. If what I wasn't saying wasn't true, guys, I wouldn't be telling it to you all. All my videos are truth. Everything I'm saying is true. I know a lot of guys, you know, you want to hear the good stuff. Y'all want to be told all this nice stuff. Then you can sue this, that, and the third in federal district court, and it all sounds good. Get out of your emotions, man. Your emotions going to get you all late and in more trouble. Get out of your emotions. Get into these books. Understand what's going on. Get some real understanding. Then you will get remedy. All that fallacy, la stuff that everybody's selling and telling you can file suits and federal lawsuits, all that other nonsense and all that BS, guys, it's not real. If it was real, anybody can be able to do it. No one has shown proof. And with that being said, that's all we need to know. So again, you all be blessed. Like, share, and subscribe. And I say shalom.